Who holds nursing homes accountable? Brought to you by Elderly Nursing Home Abuse Advocates, founder Steve Piskor.
Many people contact me and want laws made to make nursing homes accountable and liable for neglect and abuse of residents. I fully understand the frustration and helpless feeling of not being able to get help or any kind of justice for your loved one. One family wanted to make a law to have call lights answered within 10 minutes. The current law to answer a call light is 3 minutes. The 1987 Nursing Home Reform Act was passed decades after Medicaid and Medicare was allowed for nursing homes. It established minimum standards nursing homes must meet to be eligible for Medicaid and Medicare. In 2010, the Nursing Home Transparency and Improvement Act was passed as part of the Affordable Care Act. It took until 2016 before nursing homes started reporting transparency. In 2020, COVID-19 hit America, and new laws were set that gave nursing home immunity to lawsuits. In 2022, a study was done to improve nursing homes, and a staffing mandate was made law. In 2025, the staffing law was placed on hold until 2034. There already are laws that mandate accountability and liability for nursing homes. The problem is not with the law itself, it is enforcing the law. What do you do if a call light is not answered in 3 minutes? Who is responsible for enforcing this law? It is not the Department of Health, Ombudsman who is with the Department of Aging, or the police. The responsibility lies with the facility, which includes all employees. Also all healthcare professionals visiting the facility and hospitals. The Elder Justice Act, enacted as part of the Affordable Care Act, strengthened mandatory reporting requirements by establishing additional funding for adult protective services and creating new reporting obligations for long-term care facilities. Federal laws by the Center for Medicaid and Medicare Services require facilities to report incidents to the proper authorities. State laws have more specific reporting requirements. The facility must ensure the laws are followed. If any law is broken and results in actual harm to the resident, then you should call an attorney and they will guide you on what can be done. We are not attorneys and do not give legal advice. Many people tell me they have a mountain of evidence and no one will take it. The rules of evidence is basically the same in civil and criminal court. The procedures are much different. In civil court, you need a preponderance of evidence, and in criminal court, it must be guilty beyond a reasonable doubt. Evidence is a complicated issue, and the judge makes sure both parties get a fair trial. What you think is evidence might not be admissible in a court of law. You should research the rules of evidence. We have been fighting to get cameras in all long-term care facilities for almost 15 years. The law was passed in 2021. Ohio passed Esther's Law, named after Esther Piskor, who was brutally abused in a nursing home. The following year, we helped get the law passed in Nevada. We have worked in Alabama, Florida, North Carolina, Pennsylvania, Michigan, Wisconsin, and Iowa, and all of them used Esther's Law as their guide law. The camera law failed in all of these states. We are still working with legislators in these states, and we are trying to make Esther's Law a federal law for all states and all long-term care facilities. You can help by signing and sharing the petition listed in the description. This is the only way to bring nationwide attention to this fight for a federal camera law.